Get ready for the dictation. Start. This appeal has been filed against the judgment and order dated 27/9/2012 passed by the High Court of Chhattisgarh at Bilaspur in criminal miscellaneous petition number 765 of 2011, whereby learned single judge of the High Court dismissed the petition filed by the appellants herein. The brief facts of the case are that Sri Manoj Kumar Sarma, the appellant accused, who was serving in the Indian Air Force at the relevant time, got married to one Nandini on 27/4/1999. On 29/1999, one Nandini Sarma committed suicide at her matrimonial home. The information with regard to the same was lodged by the security officer of the Indian Air Force at Police Station Ambala. On 22/9/1999, post-mortem was conducted on the body of the deceased and the body was handed over to the relatives for performing last rites. On 22/9/1999, the officer in charge of the investigation submitted a report, being number 26, stating that there was no sign of foul play in the occurrence. On the basis of the investigation, on 24/1/2000, a final report was submitted before the sub-divisional magistrate. Simultaneously, a court of inquiry was also convened to investigate into the alleged role of the appellant accused, but after completion of the inquiry, the case was finally closed on 25/7/2000. After 5 years of the closing of the above case, a fresh first information report dated 29/5/2005 was got registered by Sri Shashi Bhushan Sarma, brother of the deceased, against Manoj Sarma, that is appellant number 1 herein, Hiralal Sarma, Mahavir Prasad Sarma, and Srimati Hemlata Sarma, the father, uncle, and mother of the appellant number 1 herein respectively at PS Bhilai Nagar under sections 304B, 498A and section 34 of the Indian Penal Code 1860. Being aggrieved by the filing of the FIR, the appellants herein filed a writ petition before the High Court. The Division Bench of the High Court wide order dated 25/7/2005 directed for the continuance of the investigation of the alleged offence. On 4/4/2007, the said writ petition was withdrawn with the leave of the court, and the appellants herein filed criminal miscellaneous petition, being number 612 of 2007, before the High Court under section 482 of the Code of Criminal Procedure 1973 for quashing of the FIR. Learned single judge of the High Court wide order dated 17/10/2011 allowed the proceedings to continue with a direction to the police to hold fair and proper investigation to ensure logical conclusion of the same without unnecessary delay. An application for modification was filed for modification of the order dated 17/10/2011 in criminal miscellaneous petition 612 of 2007 on the ground that during the pendency of the judgment in the matter, the charge sheet came to be filed by the police before the court, which was allowed wide order dated 17/11/2011. Further, the appellants herein filed criminal miscellaneous petition being number 765 of 2011 under section 482 read with section 397 of the code before the High Court for quashing of charge sheet and cognizance taken thereof by the Judicial Magistrate First Class, Durg, dated 3/9/2011 and 13/10/2011 respectively, in criminal proceeding number 805 of 2011, arising out of crime number 194 of 2005, registered at PS Bhilai Nagar, District Durg. Learned single judge of the High Court wide order dated 27/9/2012 dismissed the petition filed by the appellants herein. Aggrieved by the above said order, the appellants have preferred this appeal by way of special leave before this court. The court heard Mr. Sushil Kumar, learned senior counsel for the appellants accused, and Mr. Atul Jha, learned counsel for the respondent state. Mr. Sushil Kumar, learned senior counsel for the appellants, vehemently contended that since the place of incident is Haryana, the FIR and the cognizance of the offence could not have been taken at Durg. Learned senior counsel further submitted that the earlier or the first information in regard to the commission of a cognizable offence satisfies the requirement of section 154 of the code, and there cannot be second FIR or fresh investigation of any subsequent information in respect of the same cognizable offence. The investigation was carried out at Durg in Chhattisgarh, and the deceased never resided at the said place after the marriage, and thus the court at Durg had no jurisdiction to proceed with the prosecution. Learned senior counsel finally contended that the present charge sheet is a sheer abuse of the process and has been filed without any basis on the FIR, which was lodged after 5 years, that too on the basis of anonymous letters. Per contra, learned counsel for the respondent state submitted that no FIR was lodged at Maulana police station, nor was there any investigation carried out into any allegation of commission of a cognizable offence, but upon receipt of information regarding death, the police had conducted inquiry under section 174 of the code and submitted a report to the sub-divisional magistrate. Stop.